Prof. Nomlomo. They have supported this conference. Members from executive management, they've also been here. Then we get to our Dean, Prof. Khailing. And as I've said, she's really set the example, being very vibrant and energetic. And some of you may think she's younger than most of us here. Also, the chair of the MBALI conference, Prof. Kasiram. And when you speak to Prof. Kasiram, you can just tell how passionate he is about this conference. And I'm sure, I think when he does the vote of thanks later on, you will see that passion really coming out. So thank you, Prof. Kasiram. Also members of the MBALI organizing steering committee, led by Mr. Hiralal, I don't see him here, and Dr. Calvino. They've been running around quite a bit, but also other members of the committee have also been running around quite a bit. So we also thank you. Members from the Faculty of Commerce, Administration and Law, academics and students from our faculties. Also colleagues from the other institutions, our guests from other countries that have graced us with your presence. Thank you very much. Now, seeing that we have been doing things slightly different, I do have a surprise for us, but I think I'll hold that for after the judge. Our first speaker for today, obviously, is Judge Dlwati, and she's actually under pressure in terms of the fact that she has to be in court by 10. So I'll introduce her very quickly, and then we'll move to her talk, and then we'll get to the surprise. But just to introduce the judge, and I'm very honored to introduce Judge Toba Poyo Dlwati. She's the first female judge president of KwaZulu-Natal. And the judge was born and bred in the rural village of Ngobo. She matriculated from the Mount Arthur Girls High School in Lady Frere, and thereafter completed her B.Proc at the University of Transkei, which is now the Walter Sisulu University. She would later complete a postgraduate diploma in tax from the University of KwaZulu-Natal. And in 2005, she acquired a certificate in commercial law from the BLA Legal Education Center. In 1996, a young Poyo Dlwati relocated from the Eastern Cape and settled in Pietermaritzburg, KwaZulu-Natal, where she took up a teaching post at Zulu High School. I hope I pronounced that right. She also took up casual work at the Truworths clothing store in the city. She's married to Dr. Dlwati, a neurologist, and is blessed with beautiful children. I'm not sure how many, maybe Advocate Sugoni can assist with that. But the judge's legal career started in 1997 when she did her articles of clerkship at Jenny Badri and Associates. She didn't stay long there and later ceded her articles to Hoskins and Ngobo attorneys. It is at this firm that the judge's career thrived, and she quickly rose to the ranks from professional assistant in 1997 to director in 2000. 2 years after her initial admission as an attorney, she became a conveyancer, that is in 1999. In addition to being an admitted conveyancer, she's also a qualified notary. Joining forces with one of her partners of her former firm, the judge would later establish her own firm, Ngobo, Poyo, and Diedrichs Attorneys in 2000, where she stayed until her appointment as a judge in 2014. While juggling the demands of a busy attorney's practice and being a new mother, the judge also played an active role in the affairs of the legal profession in what can easily be described as an activist streak. She joined The BLA, which is the Black Lawyers Association, Pietermaritzburg branch, at the very commencement of a legal career in 1997, and later became its secretary in 1999 and chairperson in 2003. She was also the secretary of the KZN branch of the South African Women's Lawyers Association from 2007 to 2014. The vice president from 2008 to 2010, and later president from 2010 to 2012, and the SADC Lawyers Association, representing the interests of lawyers from 16 areas in South Africa. Perhaps more importantly, she became the first Black woman vice president in 2003 and later president of the KZN Law Society, which is the legal regulator of the attorney's profession in the province. The judge also sat as an expert assessor in several criminal trials between 2003 and 2011, until she started acting as a judge of the KZN High Court in October 2012. She held at least 6 acting stints before being permanently appointed as a judge on the 1st of June 2014. She joined the South African chapter of the International Association of Women Judges in 2016 and was elected vice president in 2021. The judge, she has penned several judgments of significant public importance, as well as in the development of the law. Unfortunately, we don't have the time to go into that, but you can Google that to read some of her judgments. The judge is a true role model to many young women out there, as she embodies the change that she desires to see and possesses the emotional intelligence necessary to motivate others. She's a great leader because she's able to balance her professional and personal leadership skills. Like her judgments, she's willing to take on challenges head on, decisively, effectively, and inclusively. With that, I give you Judge Lwati.
Thank you, Prof, for that kind introduction. Yeah, I thought when you said you were gonna go through that introduction quickly, you really meant quickly, but I can see we don't have the same type of definition of quickly. But be that as it may, thank you so much. And it's such a great honor for me to be presenting this talk to you this morning. And I'm very sorry that I could not be able to make it personally, but I will endeavor in the future to come through. Perhaps I can just mention to you that early after also years of my appointment as a judge, I did come through to the university to commemorate Women's Day in August. I can't remember which year, but as I said, I've been there as a judge, and I will certainly come there as a judge president, because rural areas are very close to my heart. As you have said, I'm from Engcobo in the Eastern Cape. So I know what it feels for people to not be able to come through to your area. And I know how it feels when they do come, especially when it's far as the university. So thank you for that. And I undertake to keep my promise. And thank you also to Advocate Sokoni for ensuring that I accept this invitation, because he almost was putting I don't want to say a gun on my head to make sure that I do make the presentation, even if it's virtual. But thank you for that, Prof. Prof that introduced me, I have 2 children, a daughter and a boy. So yeah, I don't have more than 2, because I am number 2 of 11. So I dare want to go past 2, but I don't think I would be able anyway now, because I've never seen it live. Let me then come back to the topic for today, which is mediation and the courts. I will send you my paper after presenting to you, because our network is unstable. I don't know what's happening. So I don't want to risk sharing the screen and then it's not getting through. But if you can just listen to me, and I will make sure that I send the presentation through. Our courts are really trying to make sure that we have court annexed mediation. What is mediation? It is the process which assists the parties to resolve the dispute between themselves. And the mediator is the one that is facilitating the discussion between them. And it assists the parties to identify areas of compromise and generating options in an attempt to resolve a dispute. Mediation is different from litigation and arbitration, because in mediation, parties are decision makers. The desired outcome is a negotiated and a settled solution, and which is reached by the parties. Different skills are needed by a mediator, because the mediator does not mind. What is the purpose of mediation? In Rule 71 of the Magistrates Court, they summarize what the purpose of mediation is, and they say it is to promote access to justice, to promote restorative justice, to preserve relationships between litigants or potential litigants, which may become strained or destroyed by the adversarial nature of litigation. It is to facilitate an expeditious and cost-effective resolution of a dispute between litigants or potential litigants. It is to assist litigants or potential litigants to determine at an early stage of the litigation or prior to commencement of litigation, whether proceedings with a trial or an opposed application is in their best interest or not. It is to provide litigants or potential litigants with solutions to the dispute, which are beyond the scope and powers of judicial officers. In South Africa, parties to a civil dispute may either engage in private mediation or in court-annexed mediation. The post-disputes is regulated by the Magistrates Court in terms of Chapter 2 of the rules, and it starts from Rule 70 and up to Rule 88. In the High Court, it is currently Uniform Rule 41, capital A, but it is not fully fledged mediation. In mediation, there is what we call positions and interests. Lawyers need to understand that mediation is not an adversarial process. It is not focused on rights, but on interests. It is focused on problem solving and not litigation advocacy. It's all about finding a solution and not a winning or losing a kind of scenario as you would find in court. In litigation, parties often state hard positions. Positions are hard demands that parties will make against the other one. It is what they want. It is followed or aligned to the legal contentions made that would have been made on the papers. And parties tend to be unshiftable in their positions. For example, in a joint primary residence,
Sorry, Judge. We can just interrupt you. If you could close your video so that you would come across as more clearer.
For instance, a party can say the joint primary residence cannot be in to have primary residence. But in the Am I back on?
Yes, Judge, you're back on.
Yes, sorry about that. I don't know what I pressed whilst I was talking. So I was saying that the interests reveal why the party is holding their particular position, what is motivating the demand, because the mediator can see on the surface what that interest is. The interests are the underlying drivers, and the mediator needs to be able to identify the interests. The interest and not the demands is what provides the avenue to an agreed solution. The important question for the mediator is not the what, but why. So it is essential then for the mediator to practice what we call active listening. It is important for them to understand what is underlying that particular position, because in listening to each party, the mediator must actively peel away the layers of what is being said, both verbally and non-verbally, expressed and unexpressed. There are obviously the do's and don'ts of the mediators, because they need to be alert and focused. You need to be able to observe posture, the facial expression, eye contact, and the mediator must not fiddle, with your hands or anything like that. And be patient and empathetic listener. Allow a party to say what they want to say, because remember, in mediation, they are expressing what they have never been able to express in the court papers. And sometimes as a mediator, you can get more reaction even when you are silent, and you use that silence when it is useful. And you need to try to be as impartial as possible so that they don't recognize your own biases or value system. It's important for the mediator to listen to them and not judge them. Take off your judging hat. And the parties need to know that mediation is private and confidential, and it will not have any publicity that can follow afterwards. So constructive questioning also is key to the mediator and the parties, because it helps the mediator to control the parties. Because even though you are not adjudicating, your role is no means passive. You need to guide the solution-focused process. You need to get the information, the interest, and assist the parties. As I have said, it helps the parties to self-reflect, assess the nature and the history and impact of the ongoing conflict. They will obviously vent their strong emotions, but you need to clarify their interests and their goals, whilst also trying to explore possible solutions. For instance, I can make an example. A party can say, let's just take a process of a divorce, for instance, and say, I don't want I don't want my children to be exposed to various girlfriends that he has. So as a mediator, you can then turn around that question and say, so as I understand you, your values are important to you. So you haven't repeated what she has said, but you haven't downplayed what she has said, but the other party understands what her needs are. Hence, you are making it as neutral as possible when you say, so values are important to you, because why is it important for her, for the children not to be exposed to various girlfriends? It is because of the values that they espouse. So there are different types of questions that you can ask as a mediator, but you must be guided by the questions, and the questions must encourage openness and dialogue. But no questions must leave a party pressed or feeling defensive or challenged. For instance, in a closed question, there can be a question that says, is there no possibility that you would consider joint parental rights, versus an open question, what for you will be the most harmful for your children? So you see there, I think an open question is opposite of the kind of questions that judges hear under cross-examinations. So the open questions, they serve the proper purpose because they are not closed, but they give them the opportunity to be able to understand what is underlying in their interests. So why do we advocate for mediation in our courts? It is because we believe that it can restore quite a few things in our country. They are, accordingly, now, I think we all agree that we live in somewhat an angry society. I think it is angry because people never have time to reflect and to say exactly what it is that they want, because all of their emotions are summed up in court papers, but they never really have an opportunity. I'll tell you an example of one of my colleagues that had a mediation in a divorce matter. And this lady and the husband, obviously, were going through the process. And at the end of it all, she was not happy with the outcome, but she said, oh, today I feel like I have been heard, I have been listened to. So it's important for people to pour out what makes them angry. And for us in the judiciary, if we come to mediation, it definitely will reduce our court roles. It definitely will promote access to justice. It will promote restorative justice. It will preserve relationships between litigants or potential litigants, which may become strained or destroyed by the adversarial nature of the litigation. It can also facilitate an expeditious and cost-effective resolution of a dispute between litigants or potential litigants. It assists litigants or potential litigants to determine at a very early stage of the litigation or even prior to the commencement of litigation whether proceedings with a trial or an opposed application is in their best interest. It will provide litigants or potential litigants with solutions to the dispute which are beyond the scope and power of judicial officers. We all know that court processes take forever to get finalized. So with mediation, it can be started today. By the afternoon, you are done. So it is definitely less cost effective, but it will also reduce our clogged roles in the courts because, excuse me, I think you have seen the article that was on the ground up a week or two ago, where they lament about the shortage of judges, and this results and has got ripple effects like long list of reserved judgments, the strain that the judicial officers, because of the work that is just too much and it's never ending. So it would certainly help, because in a mediation, there will just be a settlement agreement. A judge or a magistrate will not need to write a judgment. But even though it's court annexed mediation, we're not saying that it should be done by the judges or the magistrates. But obviously, when we're starting the process, that is what we prefer should be done. But in the long run, we can accredit various people who will be trained as mediators to certainly be mediators. In 2018 or 19, a group of 7 judges was sent to Utah in the United States by the then Chief Justice, Justice Mogoeng, to be trained in mediation and to be trained as mediators because of this very need of the court annex mediations. I was fortunate that I was part of the 7. So one was from KZN, one from the Western Cape, one from the Eastern Cape, 4 from Gauteng, because 2 were from the Gauteng, South Gauteng High Court, and then the other one was from the North Gauteng High Court, and both the deputy judge presidents, meaning the retired Judge Mujapelo and Judge Aubrey Ledwaba. So we all went and were trained, and we obviously came back sold out, and we did our report to the Chief Justice. And I can tell you now that the Law Reform Commission and also the Rules Board are looking at identifying cases where we can have mediation and where it can be compulsory. For instance, you say to the parties in family disputes, for instance, your divorce, custody, even chieftainship or kingship disputes, deceased estates, when they fight around about where to bury a person, or even who has a right to bury that person. So those are the type of matters that we would want to see being subjected to mediation before any trial date is set down, because we do believe that it is a speedy process and that parties can benefit greatly from that. And I've alluded to the fact that the communication and disclosures made during mediation stage is confidential, and it is inadmissible as evidence. And the mediation process is not confined to the aim of settling the dispute, but the role the parties may reach an agreement on issues which will not require the court to make a determination. The court can never make a determination on whether this person has been respected or not throughout the process of a marriage. But it is only in mediation that you can get down to those issues, for instance. As time goes, we will have to obviously have a buy-in of the practitioners. We'll have to have buy-in of the community and society at large, so that they know that this is an option that they can utilize. Already in the magistrates' courts and also in certain divorce matters, mediation is used in terms of the magistrates' court rules that I have alluded for. In labor relations guided by the Act 66 of 1995, all matters there that arise between employees and employers are first mediated. So we have had mediation in our country for the longest of times, particularly in labor matters. So I believe that even in civil courts in particular, I don't think that in criminal matters we would want to go there immediately, but it is something that can be considered. So it will definitely benefit the parties so that they can get to the expedient and cost-effective way of resolving the disputes between the parties. Vulnerable parties will be heard. They will engage in all of the discussions. So we do believe that mediation should be a way to go, particularly in various matters that I have identified. As I conclude, Program Director, I do think that when you have equipped yourself with the skills of mediation as an ordinary person, for instance, I have become a better judge with the mediation skills, because you develop empathy, you develop patience, you understand people's point of views, even as a family or as a mother or a wife. You listen more and you are patient. So it develops you as a person and equips you for better. So I think that if we were to have compulsory mediation in various aspects of our civil cases in particular, it will be a appreciated step forward in our country. I will stop there for now because of the time constraints, and thank you so much for the opportunity, really. And hopefully next time I'll be able to come in person. Thank you.
Thank you, Judge President, for that informative talk. I know you have to rush to court, so can we excuse you now?
Yes, thank you so much, Program Director. Thank you.
Thank you, Judge.
Bye.
Bye. Now, colleagues, if you really look at this topic, it's not purely law, because mediation actually applies to all walks of life, and it's an effective tool in the workplace. In fact, if we listen to the judge carefully, we would have heard that mediation offers the parties greater control over the outcome of their dispute. It's a voluntary process, which is very important, and it helps parties focus effectively on communicating with each other as opposed to attacking each other. So that's very important. It also saves a lot of time and money. It's private and confidential, and helps discover the real issues in the workplace. Now, if you take the matter to court, you're fighting over, technical issues and so on. But it actually helps discover real issues at the workplace. It also, I think, takes away the uncertainty of judicial outcome, because you don't know what's going to be the judgment if you take the matter to court. It allows parties also to move on from difficult relationships. Also, if you really look at it, neither of the parties loses, and the interests of both parties are taken into consideration. So I think from what the judge has said, I know she's, in court most advocating for a process that alleviates the court role. And it's a huge problem, because in the past, I recall when I used to practice, sometimes we had to wait 2 years before a matter, was actually heard in court. I don't know now, but sometimes you have to wait a year or two before the matter is enrolled. So mediation is an effective tool that should be considered. Thank you. Now, colleagues, we've made a few adjustments to the program. There's going to be a short video that's going to be played from CMD in a short while. That's a 5-minute video dealing with the theme of Africa Rising. But as I said, this conference is full of surprises. And it started off with the dance, with singing, eating. And I think it's now time for a poem that was penned yesterday. So in terms of the title of the poem, it's Africa Rising. Possibilities, priorities, partnerships. Stunning beauty, rich history, and vibrant culture. A land of greatness, bloodshed in the past, but now proudly flowing in our veins. African heritage, once obscured, hidden, and contained, but now slowly rising like the savannah's golden sun against a backdrop of majestic mountains, stunning wildlife, and pristine beaches. In excitement, our hearts beat like African drums. Our feet move in unison like traditional dancers. Vibrant energy, human ingenuity, boundless creativity, embracing as one. We stand up proudly, diverse but unified, our hearts lined with gold, our soul glittering like stones, our continent giving color to the world, our minds sparking nodes of African thought. We are the creators of indigenous knowledge, intellectual minds free from our shackled past. Let us unite in this golden age of Africa rising. Let us celebrate a place of unparalleled beauty. Let us rise and salute the African mind. Africa rising, our time is now. Thank you. Just an announcement, colleagues. I've been told that there is a survey that needs to be filled, and obviously that's very important. You can give positive and negative feedback, but we hope that you will fill in the survey so that we always want to improve in terms of future conferences. So please fill in those surveys. We'll now move on to the short video. Thank you.
If you are talking about Africa rising, what we'd like to see is the rise of all Africans, not just a minority. It's like when we're talking about economic development. Economic development of the country does not speak to the infrastructure only, but it speaks to the improvement of the standards of living, including of those who are not AIDS.
Based on the theme of the conference, I would like to see Africa rising with regards to entrepreneurship, because I feel like in our education system, we train our students to become job seekers instead of job creators. So in this case, with regards to unemployment and everything, I think it's important to capitalize on entrepreneurship.
I believe that we can start embracing our diversity, and that we start looking at the opportunities and the people and the culture and the resources that we have, and then use them to build a more sustainable and inclusive society for all.
One way that I would like to see Africa rising, especially in matters of trade, and I think the signing of the African Free Trade Continental Agreement is going to be very important to allow for the movement of goods on the continent, but also allow for the movement of people, traders across the continent to help in developing Africa and Africa to Africa interaction, but also importantly, getting African products to be known outside with first an appreciation of African products on the African continent.
What I would like to see in terms of Africa rising is states collaborating together and also helping one another in terms of the resources in order to uplift Africa as a continent in terms of our educational systems, in terms of our cultural system, and also cutting barriers in terms of crossing borders and assist one another in many forms in terms of exchanging knowledge through research, community engagement, and also service learning.
Thank you, CMD. I think that was an excellent video, and it was quite a nice surprise also. So colleagues, just to recap, in terms of the Dean's message, those of you that have read it, I'm sure all of you have, in terms of the program. She did mention that one of our objectives in terms of this conference is to find solutions to the world's and its own problems. And in Africa, there are a lot of problems. We have the intellect and capacity to solve these problems. And thus far, just sitting in some of the discussions, the sessions that took place, we can say that there have been a lot of positive discourse that has taken place. We're on our way to finding solutions, and hopefully today in this final day, we can come up with more vibrant types of solutions. That being said, I think my job as the program director comes to an end for this session. We are going to have a photo session in a short while, and there's also a tea break at 10:30. So, Prof. Geling, would the photo session take place now?
What we've done, colleagues, because we have so many collaborators and so many groups here, is to make this photo session, tea session, quite long, because you don't see your friends. So what I would really ask is that you take your co-author or your university or whatever, and CMD has set up the background. Please go and take those pictures. We will send it afterwards to you all, but we would also love to put them on our website, to show who is communicating, who's working together. So anyone that wants to take a picture, we will take the whole big group, but please, there's enough time now to have a proper picture, better quality than what I'm doing with my camera and cut off half the heads and only getting the feet or something. So please take this opportunity during tea time, go take whatever you want to, and we will make sure that we put on the names, and we will send it to you, and we will also put it on our website. So a longer tea today. I'm spoiling you on a Friday. Longer tea.
Thank you for that, Prof. Geling. So colleagues, let's take this time to create new memories by taking photos with some of the new friends that we've made over the last couple of days. Remember, it's not time to run away after this first session. There's going to be a breakaway session, I think, that commences at 10:30. So please stay behind for that. And then there's lunch, I think, around 1 o'clock. Thank you.